We're live?
Yes, sir.
Okay, let's go on the record on this case. Mr. Herrera, why don't you introduce yourself, give us the cause number for this case as well as the name of the case. Mr. Herrera?
Oh, I'm sorry, Your Honor. My name is Ethan Harima. I am Dennis Zedrick, the plaintiff's attorney. This is the case of Zedrick, the builder, cause number DC 1906203.
Okay, and then defendant, if you want to give your announcement.
My name is Stanislav Builder. I'm a defendant pro se in the said case. The case number DC sorry.
Yeah, I think you already gave that. So, all right, let's go ahead and proceed.
Thank you, Your Honor. Here on plaintiff's motion to compel, and plaintiff served its third request for production and first set of interrogatories back in November of 2019. In response to over 40 requests for production and 25 interrogatories, the defendant produced only 5 files and answered 1 interrogatory. Now, this motion was set earlier this spring, but defendant's former counsel and I personally spent a few hours conferencing, trying to work out these objections and trying to work out production and reach an agreement. And we did over the phone. And defendant's former counsel agreed to withdraw objections and produce documents to approximately half of the request for production, and agreed to withdraw objections and answer all but 3 interrogatories. I sent over a Rule 11 agreement to have this agreement memorialized, and that very day, defendant's counsel withdrew without conferencing with me. So we believe there's an agreement here. There's outstanding discovery that needs to be produced. We believe that because of this outstanding discovery, that the defendant's motion for summary judgment is not ripe. We'd like the court to compel this production that was already agreed to.
Okay. Have you conferred with the defendant on this?
I conferred with the defendant that this was being set, and no agreement was reached to produce any documents or produce additional discovery, Your Honor.
You guys haven't consulted on that?
No, Your Honor. Just the setting of this hearing.
All right. Let me go ahead and share screen this. This is the proposed order as I understand. Is that right?
Correct, Your Honor.
Okay. And so, and this is, I guess, the agreement you would reach with opposing counsel?
Not entirely. There are some we did not reach an agreement on, but I can give you the numbers on what was agreed, if that's okay.
All right. Have you had a chance, Mr. Builder, to look at all of this?
I had a chance to look at it, Your Honor, and I'd like to add that the opposing party had set this very motion to compel 4, if not 5 times since February, when they actually filed it. It has been set for hearing and then removed, set for hearing and then removed. They have not tried to reach out to me with any of those after Mr. Campbell has left the case. Me and Mr. Campbell were not anywhere near agreement with the opposing party on what we're going to produce here. Most of those requests are either irrelevant to the existing causes of actions or violate the attorney-client privilege. The very first request demands me to produce a bunch of communications with my attorney, which Mr. Campbell has rightfully objected, for example. And now the discovery is over. The other party had every chance to reach out to me with Rule 11 agreement. The other party had every chance to reach out to me for any of those questions.
Let me make sure I kind of recall what's going on here. So I had denied the TCPA motion on this, correct?
You actually approved. It was
That was-
approved.
It is granted, Your Honor.
It was granted. The plaintiff has lost a fair portion of this case under the TCPA.
Okay. Oh, say I denied in part, granted in part. And so we're going to be discussing the amount of the attorney's fees that I have to award under that.
For the TCPA, yes.
Okay. Does this go to, do these documents go to that issue, the motion for attorney's fees at all?
The first request certainly does, Your Honor. We're asking for billing statements, which I believe we're entitled to as we're seeking attorney's fees. But the vast majority of these requests deal with the remaining claims the plaintiff has, which include stalking, wiretapping, and like defendants of counsel of record at the time agreed they were relevant and agreed to withdraw these objections. So, and
Let me do this. I need to go grab a copy of this order. All right, I have this order here. The printing was screwed up. Let me try again. I'm sorry about that.
no worries.
My fault. Okay, can you guys hear me?
Yes,
Yes.
Your Honor.
Okay. So request for reduction number 1 is billing statements. I'm going to overrule it, but just to the extent that require invoices and billing statements.
Your Honor, if I may, the affidavit of Scott Campbell has this information in the motion for attorney's fees.
Okay, that's good. Number 2, why is this relevant about the termination of the engagement letter? Why is that relevant?
Your Honor, we believe that Mr. Builder's former attorney had communications with him and telling him to stop harassing my client. So that's really what we're looking for in that request. So I'm not sure if
But
it's phrased
that's going to
properly.
be attorney-client, right?
Yes, Your Honor.
Yeah, I'm going to sustain that one. Are you even requesting number 3?
I am requesting. That was one that was actually agreed to by Mr. Campbell.
All right, that objection is overruled. Number 4.
I believe 4 has been omitted from the order by accident.
Well, then we're not doing it. We have 6 is the next one, I guess.
6 was also agreed to by Mr. Campbell.
But if I may, Your Honor, Mr. Remick, can you please produce any evidence that Mr. Campbell has agreed something of that nature with you? I do not recall any of that being agreed by me or him.
I have a draft of my letter sent to him. I don't have it on me at the moment, but I'm happy to produce it.
To be honest, that isn't really relevant to me. I'm just looking at these each independently. So you can say that or not say it. I'm looking at them independently. All written or verbal communication correspondence you had with anyone other than Scott Vendel about the particular interaction. Okay, that's overruled. 7.
Excuse me, Your Honor. How am I supposed to produce any verbal communications? Maybe I misunderstand something.
Yeah, you're right. Verbal communications. I'll take out verbal. It's all written or electronic.
And why is it goes all the way back to January 2017? This case has been filed a year ago.
What are you talking about? Number 7?
Number 3, it's extremely overbroad. What am I supposed to produce? Any text message to my mom where I mentioned Dennis Zidrik? How is it even relevant? We're talking about stalking and wiretapping, Your Honor. The other parties.
Right. So I'm going to just say related to this case instead of to Mr. Zedrick.
Thank you, Your Honor.
All right. Okay, number 7.
Yes, Your Honor. Number 7, 8, and 11 are all related to the net worth of the defendant, and because plaintiff has pled for exemplary damages, we believe that's relevant.
All right, I'm going to overrule this at this point. That none of this, you can get net worth, but that's not how you're going to do it. 8. I'm sorry, this will be the objection is sustained. Eight is sustained. 11, the objection is sustained. Objection sustained on 11. 12 is sustained. All right, so this is where we kind of come into the difficulty here. So you have asserted, so we're looking at 14 now. You have asserted a claim, I guess, for exemplary damages. So they would be able to, the plaintiff is claimed exemplary damages. So they need to know your net worth.
Your Honor, it has been provided in the nearby family case extensively over the course of past few years, several times.
What would be, so there's different ways to provide net worth. Have you ever had an audited financial statement of your worth? Or I need to figure out a way to ascertain that. I want it to be as convenient as possible to you, but that he is entitled to that. So would it be through tax returns? Would it be through what exactly?
Yeah, we can do tax returns, but Your Honor, if I may ask, we have 2 causes of actions. One is wiretapping and the other is stalking. How is that financial information even relevant to any of those?
Because they're making a claim for exemplary damages and your net worth is relevant for that. So that's why we're doing that. But I'm just going to do 2018 and 2019, not all the way back to 2016.
Okay, so tax returns for 2018 and 2019, right?
2019, yes.
Understood.
And you can that will be subject to a protective order.
Excuse me?
So I don't want him to release your tax returns. Like if he files those as part of some kind of motion online, I don't want him to put that on the internet so everybody can see your tax returns.
Thank you.
It's trying to protect
Understood.
you. Any and all unedited footage of. Okay, well, this is way too broad, number 17. Okay, of the plaintiff, I can see, but of any member of his family, isn't he married to, would that include his wife?
Yes, Your Honor. Some of the wiretap phone calls include Mr. Zedrick's wife. So really, what we're looking for is in the phone calls he's recorded that we believe are wiretapped. None of those have been produced. I've had no recordings, and I know that they're in his possession because he's produced them in another case.
What? So, Your Honor, if I have produced them in the other case, then what are we talking about here?
You still have to produce them in this case.
So just copy paste?
Well, yeah, you could, I guess you could do that.
Okay.
All right, so
I'm willing to narrow that a little bit. That's what I'm going after here is for those recorded phone calls.
so I'll do of the plaintiff, but any secretive recordings or phone taps of plaintiff or other family members. It's overruled. All right, number 18.
Your Honor, 18 through 20 were also agreed by Mr. Campbell. We're looking for complaints or reports filed about my client.
Just against why against any other member of the family? Why not just the plaintiff?
Yeah.
Well, I think one of our causes of action, the harassment, deals with one of the elements is whether plaintiff reasonably feared for the safety of a member of his family. So I broadened it.
Or the member of his family, not the plaintiff.
Correct.
Okay, that's fine. That's fine. That's overruled.
Hold on a second. You don't have the cause of actions of harassment. You have stalking and wiretapping. There is no harassment cause of action.
One of the elements of stalking is what I just explained.
Just harassment. So it would be any member of Mr. Zedrick's family. Okay. All right. Number 19 is the objections overruled. How are these two things different, 19 and 20?
May have been a duplicate. Let me double check that 1 second.
Yeah, I guess they're slightly different, but okay, those are both overruled. 21.
21 was agreed. We agreed to modify it.
Excuse me, Your Honor. As for the 19 and 18, I strictly request to limit to Denny Zedrick only because Denny Zedrick is married to my ex-wife, and because Ukraine does not support U.S. Divorce, there is no legal agreement between the countries. So I had to file, for example, for a divorce in Ukraine.
So when you say any member of his family, I assume that would not include his ex-wife.
No.
I'm asking the plaintiff's attorney.
Oh, I'm sorry.
Oh, well, Your Honor, defendant's ex-wife is my client's current wife. So.
Oh, I'm sorry. Okay, of his family. Okay.
Oh,
I apologize. So, or any member of
plaintiff Zedrick's
other than his wife.
Thank you. That's for both 18 and 19, right?
19 and 20. and
Okay.
and 18.
And 18.
All right. And Natasha Builder is
She's my mother. She lives in Ukraine.
okay.
Your Honor, I think we can narrow 21 just to be any and all written and electronic communications between the two defendants.
Your Honor, this is overbroad. It's strictly
Yeah, this is
protest.
way overbroad.
wait,
No, I'm
they-
just
they
going
won't-
to I'm going to sustain the objection on this.
Thank you.
Yeah, no, I'm not going to allow that. All right, who's Ashley Love?
She's my girlfriend, and we're not together for 2 years. She has nothing to do whatsoever with this case.
Your Honor, defendant's ex-girlfriend has made accusations about my client laundering money in Russia. Various accusations have appeared on the internet and has been overall part of the harassment.
But she's not a party, right?
She is not a party.
All right, yeah, I'm going to sustain the objection. All right, 23.
Your Honor, 23 through 30 were also agreed in our agreements, as long as they were reports related to Dennis Zedrick. We had that.
That's fine. So you have to provide anything on anything related to Zedrick for them.
To Mr. Zedrick. Okay.
Yeah. Number 24, limited to Zedrick. 20.
Excuse me, Your Honor, number 24, the logs of the telephonic correspondence. What does it even mean? I don't write it down.
If you have a log, most people don't, but if you happen to have a log, you'd produce it.
Yeah,
And I'm taking out the stuff on verbal reports because that you can't produce things that are verbal. All right, limited to Zedrick for all of those. Limited to Zedrick on 26. Limited to Zedrick again on 27. 28.
Excuse me, Your Honor, it all goes back to January 2017. The case was filed a year ago. It doesn't make sense.
I'm going to still allow it on these, limited to Zedrick. Hopefully there won't be any, but
Okay.
no verbal reports. Zedrick overruled. Okay. 30. Same thing, limited to Zedrick. $31 is going to be limited to Zedrick as well. 32 is overruled. So 31 and 31 is limited to Zedrick. 32, and you'll get a copy of this order, is overruled. 33 is overruled. 34 overruled. And there may not be some documents related to this. 36 is the objection sustained. 38. I don't know what this is about. What is RAD?
Your Honor,
it is my previous employer. They have nothing to do with this lawsuit whatsoever.
defendant submitted an affidavit bringing that up.
Sustained. Uh, 39 is just objection sustained. 40, the objection sustained. 41 is objection sustained. Okay, now we're going to interrogatories.
Yes, Your Honor, and I will add that all but numbers 11, 12, and 23 were agreed to by Scott Campbell.
Okay. Objection to 2 is overruled.
I beg your pardon? Or how is it relevant?
What your telephone number is?
Oh, but they want not just telephone numbers. They want my Skype accounts, WhatsApp account. Why they want like the whole 9 yards. And since January 2017, this case has been filed a year ago. What does it have to do with this case? What does it have to do with any cause of action?
I agree. It doesn't need to go back to 2017. So it'll go back to 2019, January 2019. And then,
how is it relevant?
well, they need to be able to discover, like if there's for example, if you made a phone call to harass them or to stalk them, they would need to know what your phone number is. That needs to be established.
Your Honor, I would just add that some of this behavior occurred in 2018. So I would ask if we could split the difference here and go to 2018 at least.
When in 2018?
Well, for example, January 1st, 2018 would be my preference. For example, the Addison Police Department incident took place in 2018. I think those communications are highly relevant.
There were no police department incidents involving Dennis Zidrick in January 2018. The first accident happened in April 2018.
Provide the name, cell phone number, and email address of all 3 recruiters or headhunters. Why? No, that's sustained. 10 is sustained. 11 is sustained. I don't know why any of this stuff would be relevant. 12 is sustained. 13.
Your Honor, if I could shed some light on that. Mr. Builder filed an affidavit back in June of last year before the temporary injunction hearing, where he made these claims that he had these employment interviews and work commitments. So we were trying to discover that information.
But Your Honor, my interviews have nothing to do with this case whatsoever.
I agree. So number 13. Are the names, email address, telephone numbers, LinkedIn, and social handles for all individuals you had meetings with on the particular day that this incident occurred? Is that the deal?
No, Your Honor, that was the day of the temporary injunction hearing. Mr. Builder filed an affidavit saying he was unavailable because of these work commitments, and so we wanted information verifying that.
Okay, I was unavailable for my work commitments. What does this have to do with any of the causes of actions that you're painting right now?
13 is sustained. 14 is sustained. 18 is overruled. 19.
Can you please limit the 18 to Mr. Zidrick only?
Where is he mentioned in here?
Dennis Zidrick or Les Zidrick. See,
Okay.
and can we please let it not
just
January,
Dennis? That's fine. Just Dennis is fine.
And not January 2017, but
January 2018
or 19. Yeah.
So January 2018. All right, 2019 will be limited to Dennis, and 2018. Okay. All right. I apologize, but we're running out of time here. Limited to Dennis for 20. Limited to Dennis, 2018. Limited to Dennis, 2018. I think that's too broad, actually. I'm going to just sustain it.
Which is it the 21st?
22, I sustain the objection, so you don't have to answer it.
What about the 21?
Yeah, I agree. That's too broad too. I'll sustain that one. 23 is overruled. I'm sorry, sustained. 23 is sustained. That's it. We'll have that answered by September 15th. Have you not taken his deposition already?
I haven't, Your Honor. This is part of our agreement I have with Mr. Campbell, and once he withdrew, any agreement evaporated. So,
Your Honor, we had a hearing just 2 months ago, and the question of depositions was on the table again. And the clear answer was that the party had all the chance to take the depositions. They decided not to. They had all the time since
Your Honor, I
February.
filed a motion about this specific issue, and I'll have it separate hearing. We'll narrow that down at that hearing at that time.
Okay.
You don't have to rule on that today.
No attorney's fees, 24th of August. Okay. Sorry, guys, this is how much time I have. Unless all the folks who just showed up, have you guys reached an agreement, or are we going to have a hearing? Ms. Reisinger, Ms. Prue, any of you guys actually need a hearing, or you guys?
I'm just here to say we came to an agreement.
Is that on the motion to compel?
Yes, Your Honor.
All right, yeah, you guys had contacted us, so thank you for being belt and suspenders there. So thank you for doing that, and but it's already been canceled. So thank you so much.
Thank you.
All right, thanks. So do we have anyone here on the temporary injunction? No one. Is anyone
Yes,
here for a
I'm
hearing?
here. This is Nicole Figueroa on behalf of defendant Richard Wade. I'm here for the temporary injunction hearing. At 4
Okay.
o'clock.
And Your Honor, Paul Genender is here for defendant William Mills in the same matter.
Okay. Anyone here for the plaintiff?
I'm here, Freddie Holder.
For the plaintiff, or you are?
I don't know who. I'm a consultant with Vertical.
He's a witness.
He's a
Your Honor.
witness,
A
Your Honor.
witness. Okay.
Is the attorney here for the plaintiff? Is there an attorney for the plaintiff?
Yeah, it's Pete Harry.
Is he here or no?
Pete,
You're on mute.
Okay.
He's here. He's not. He's here, Your Honor. He's just trying to get his phone to work.
You're trying to do a temporary injunction with your phone?
Well, he's trying to get his sound on.
Who is that? I don't see who we're talking about.
Pete Harry, Your Honor.
I don't see a Pete. Oh, there's Pete. Mr. Harry, do you want to go forward with the injunction, or we need to waive it, or do we need to reset this when you can have your technology work? Well, tell me I don't know what's going on with him. Mr. Genender, tell me what's going on in this case. Do you guys need
Sure.
a hearing or not?
Well, Judge, I know Ms. Figueroa may have some things to say, but one thing I do know for certain, and I have discussed with the parties, we're on the precipice of settling this case. And I would ask that you send us to mediate Wednesday afternoon. I think we need about 2 hours with John DeGroat. I've checked his calendar. I've shared that with the other parties. The co-defendant is okay. I don't know if Mr. Harry is good or not with it. He's kind of unclear to me, but I think that would get this whole thing settled. We have spent considerable time trying to get this done. There have been some difficulties with Mr. Wade signing a document, but we think a couple hours with Mr. DeGroot might do the trick. And I think that would be a good use of everyone's time and obviate all this other stuff going on.
Mr. Harry, what do you think of that?
And I'd ask Your Honor, I think it would be helpful if Your Honor directed us to do that.
I'm fine with that, but let me see what everyone thinks. Mr. Harry, what do you think of that? You need to speak out loud, Mr. Harry. Are you trying to use your phone to? I'm not sure what to do here. Let's see. Does Mr. Harry have a co-counsel here maybe who could speak? Mr. Chu, what are you here for?
Here.
Mr.
with
Chu, it's-
Richard Wade.
Sorry.
I'm with McDermott for Mr. Wade. I'm just a corporate lawyer, so I'm going to be
Okay.
quiet.
Ms. Pennington, what are you here for?
Your Honor,
Yes, Your Honor, I'm with Paul Janender
Okay.
for Defendant Mills.
Judge, I did enjoy you getting Wilson Chu to speak in court. I know as a
I
corporate.
know.
probably terrified.
He's probably like, I don't want to do this.
He got all dressed up.
But let me just admit that I don't know a courtroom from a bathroom.
Well, some attorneys like that. So,
Your Honor, this is Nicole Figueroa for Defendant Wade. I just wanted to echo what Mr. Janender just said about mediation. I think a mediation would be very helpful. We ended up filing our motion to withdraw as counsel this morning because we've reached an impasse, we feel, with our client. And there's a fundamental disagreement about the best path forward in this case. However, we did confer with Mr. Wade, and he has agreed to attend a mediation if it was ordered by the court on Wednesday. And so we think that that might be the next best step.
So Mr. Harry, I think if you unmute, are you trying to use your phone to use your sound? Because if you unmute, your phone is muted, but you're not muted. So if you unmute your phone, that might do it.
I'm still not hearing anything.
I'm still not hearing anything either.
Yep.
Mr. Harry, you need to unmute your phone. Okay, he's leaving. Okay. Does he work with the firm or what is he? I don't know.
He has his own firm, Your Honor.
Does anyone know if that's his firm or maybe he's, oh, now that number's gone.
Your Honor, we have also filed a motion to continue today's hearing in light of the fact that we have filed our motion to withdraw. We have notified Mr. Wade, obviously, of our intent to withdraw. And we understand that he's in the process of seeking out new counsel to represent him in this matter. Mr. Wade has not consented to our motion to withdraw, but we are hopeful that as soon as he obtains new counsel, that
Is he
will.
here, Mr. Wade?
I don't believe that Mr. Wade is here now.
Was he here earlier?
I don't know, Wilson, was he here earlier?
No, he's not here.
Is he supposed to be here?
I don't think he
No.
was, he's being called by plaintiffs.
Your Honor, can you hear me now?
Yeah, we can finally. All right, Mr. Harry.
Okay. Your Honor, I'm sorry about the technical problem here. I didn't.
Mr. Harry, I think we're gonna have to send you to Zoom class because that was a little slow, but that's okay.
Okay. And I apologize, Your Honor.
That's okay. That's okay.
Let me
We're all
just.
learning.
Okay. Let me just say this, Judge. From the standpoint of our position, we think that the motion to withdraw came as somewhat of a surprise to us. I had discussed this with Mr. Ferrillo, who's not on the Zoom today, but
He is. He is on
He
there.
actually.
oh, he is. Okay. He said he was last Friday that he was going to file a motion to withdraw. And did I oppose it? I said, no, we didn't oppose the motion to withdraw, but we certainly are going to go forward and we don't want to agree to a motion to continue. He never mentioned anything about a motion to continue last week. And our position is that The problem with Mr. Wade is that he has simply openly violated this Rule 11 agreement. And as a result, I don't know that the motion to withdraw is timely under the circumstances. I didn't see a letter attached to their motion to withdraw, but I understand they did not send it out 10 days in advance of filing the motion to withdraw. So I don't know how that could be a basis for continuing the hearing. Your Honor, and I don't know, I think everyone's representing to you that we're somehow just days away from signing a settlement agreement. That's just not true. There's no way that this thing is going to mediate in 2 hours or 2 days. This settlement negotiation has gone on for 3 months. And we would agree with Mr. Wade's counsel that he has been uncooperative. If the court wants to set us to a mediation, I don't think it would work, but I again don't think it should be a reason to discontinue this hearing. And I really don't understand if Mr. Wade and his attorneys are saying, oh, sure, we'll agree to sit in a mediation in 2 days. If you waive this hearing, I don't know why they can't, for some reason, represent him today because of these irreconcilable conflicts, but somehow they would be able to represent him in a mediation. We are not on the verge of signing anything, Your Honor. In fact, as counsel, I can advise the court that we are moving forward to remove the defendants as directors from the corporation in a corporate resolution. And so my feelings about a mediation are not at this point that it would make any difference. But I also want to say that for purposes of the hearing, we've got Mr. Holder here. It seems to be undisputed that Mr. Wade has been openly violating this Rule 11 agreement on a continuous basis since June the 1st. I think Mr. Holder will take maybe 10 minutes to testify. And as a consequence, it should be fairly short and sweet. And none of the, I'm not sure that the motion for continuance is timely under the circumstances. And we certainly have opposed it. There is no reason, frankly, that the court cannot proceed with the hearing because it doesn't preclude having a continuance nor a resolution of the motion to withdraw over some period of time. And my concern is that it's just another delay tactic that Mr. Wade is throwing up at the last minute to keep from having to answer the piper in this case. Your Honor, you know from a case that's cited in our application, which is the Mokhtarian versus Wade case that I think the court has had to deal with. You entered a receivership order in that case over a year ago. And I would just remind the court that this is just what Mr. Wade does. If you order him to a deposition, he doesn't show up. If you order him to produce documents, he doesn't do it. And even when the court ordered him to show up for a deposition, he didn't do it. So our contention is there's no reason why this issue cannot be resolved today. If the court wants us to send us to a mediation this week or some other time, I think that's fine. But my clients would like to have some assurance that Mr. Wade will not continue to just simply loot the corporation by writing checks to himself and making unapproved charges on the debit cards. And as a consequence, we think this could be short and sweet, and we have provided the court with what we think is an appropriate order to enforce the Rule 11 agreement.
Response?
Yes, Your Honor, if I may. Just a couple of things to address. First, we did serve Mr. Wade with the letter in accordance with the local rules. It was not attached to our motion this morning. That's an administrative error, which will be corrected following this hearing. But I think the more important point is this sense of urgency that Mr. Harry seems to be voicing, we would disagree with. This hearing really comes down to about $8,000 worth of business expenses that were incurred over the span of 2.5 months. So this is not irreparable or imminent harm by any means. And Mr. Harry has known about those expenses since mid-July. So I'm not sure that this is the type of breach of an agreement that would require injunctive relief. But
let me ask this. I'm sorry to interrupt you. Let me ask this. You guys agreed to a Rule 11 agreement that looks like it's essentially what you would see in a temporary restraining order or a temporary injunction. Let me see if I can share screen it here. Where'd it go? That's not it. I think this is it. I mean, this is the exact kind of thing that you would see in an injunction. Shall not use the credit cards. Shall not write checks. Shall not destroy or hide information. I mean, it sounds like you guys agreed to basically an injunction, and so why wouldn't we just convert this from why don't we all just agree to convert this from the Rule 11 just directly into an injunction? It seems like you guys already agreed on this. Why do we need to have a whole hearing on it?
Right.
If we just do the form of the order.
I think that
Your Honor,
the relief that Mr. Harry is seeking in this, with this temporary injunction that was filed in connection with his second amended petition, goes beyond what we agreed to in the Rule 11. And so it's not the same.
So if he limited to what was in the Rule 11, you'd be okay with it?
We would have to consult with our client, but I think he would be amenable to that.
I mean, your client really should be here though, right?
Yes, Your Honor. He was not cited to testify in this, so he was not here.
Your Honor, if I could address that, I think you kind of hit the nail on the head there. This is nothing more than an attempt to enforce a Rule 11 agreement that the defendant has just willfully ignored. The Rule 11 agreement provides by terms that can be enforced by a injunction, and that is exactly what we're asking the court to do. The problem is this: the defendant agreed not to use the debit card for personal reasons. He agreed not to write checks to himself. And the immediate, or actually the irreparable harm to the company comes from a number of things. And I think Mr. Holder can testify to those things. I don't think that during this time, the rent is being paid, other employees aren't being paid. In the middle of all of this, the SEC stopped and halted trading in our stock, partly because the franchise taxes had not been paid to the state of Delaware for 2 years. Mr. Wade didn't pay those. Someone else in the company paid those. And so we have a real problem with the really existence of the company if Mr. Wade is allowed to sit in there. And if you simply order him to do what he's already agreed to do, he's already demonstrated that he doesn't care. I mean, the court order was enforceable when it was filed with the court.
So let me make sure I'm understanding this. So you would agree if the temporary injunction was limited to just what was in the Rule 11, you would agree to that? Yes? Mr.
We would agree to that, Your Honor. Plus, we have asked that Mr. Wade reimburse the corporation for the thousands of dollars in checks that he's written and the improper use of the debit card.
That wouldn't be in the temporary injunction. That would be in a summary judgment or something. I can't order that.
Your Honor, I'm sorry. This is Paul Janender from Mr. Mills. Okay. Can I jump in for 1 sec, Judge?
Sure.
This motion, while this motion in one sense is not directed at Mr. Mills, I will tell you, there's a fundamental problem with what Mr. Harry is trying to do on behalf of the plaintiffs. And we have an abatement before you. And I understand there was an agreed order to abate the case pending these settlement discussions. And I understand from the court that there's a notation that you wanted a hearing on that. And we didn't get a hearing on that. So all we have is an agreement to abate, but not entered by your honor. But the reason for why that abatement was agreed is important to this. They're trying to bring an action derivatively, but they don't have the corporation as a party. So there's a standing issue here for Mr. Harry to try to get money. Aside from the fact it would be a summary judgment issue, but he doesn't have the right party here because his clients are not the company. And the company is a necessary party that's not included in the case. All that being said, Your Honor, and I'm going to just only give you the conclusion, because otherwise I'm not going to run afoul of Rule 408. But this needs all the parties and a skilled mediator who can do this on Zoom, like John DeGroat can, to and pursuant to an order from you, to listen to reason as to what might happen were this settlement, which is on the lip of the cup, were not signed. There have been drafts, there have been final drafts, there have been tweaks, but this document, Mr. Harry is, I think it would be in everyone's best interest if we first subjected this to that effort as it relates to turning a Rule 11 agreement into an injunction. Your Honor, maybe I'm naive. I kind of view them as interchangeable. I know they're technically a little bit different, but it's an order of the court one way or another. So I'm agnostic as to that, Judge, as to Mr. Mills, because he hasn't violated any agreements for the court. But I do think he'd be prejudiced if this case doesn't get settled along the lines of where we're on the edge of getting to. So that's my Judge.
Judge, this is Paul Ferrillo from New York, Nicole's partner. Could I be recognized for a second?
Second.
The real problem here is we need a mediator to tell the parties this is a case that is imminently settleable. That's why I believe Mr. Fernandez brought the motion. The real problem is here, and the settlement solves Mr. Harry's problem. If the case is settled, Mr. Wade retires, and therefore there's no need for any other temporary injunctions or restraining orders or anything else that happens here. This is a case of, as Paul Janander said earlier, he needs to be told to attend the mediation, and if not told to attend the mediation, told to maybe appear before you to help facilitate the end goal, the end game here that Mr. Harry wants is to get rid of Mr. Wade. And
I would agree with you guys. I have no problem whatsoever sending you guys the mediation, but Mr. Harry is strongly opposed to that, and I don't feel like it's useful for us to delay this. I mean, what makes sense to me is we enter into an agreed temporary injunction reflecting the terms of this Rule 11 that could be enforceable through contempt. And then I could order you guys to mediation to try to work out the rest of the case. That's what makes sense to me as kind of a neutral outsider to this. Doesn't give anybody exactly what they want, but gives you most of it. Otherwise, I kind of think we have to have this hearing. So, Mr. Harry, what do you think about that?
Your Honor, my concern is I think you're absolutely right that it would make sense perhaps to just reduce what we wanted to do to an agreed injunction, because then it could be punishable by contempt. Our concern is that, as you know, Mr. Wade is just not someone who honors these kinds of things. And so given if you've seen a copy of exhibit number 3, which we circulated to everyone, it's a document that the witness, Mr. Holder, prepared. And he is the outside financial consultant to the company. And so my concern is that if we do nothing more than just say, okay, Mr. Wade, nothing's going to happen to you, but now you really have to agree to this thing. He will just be free.
Let me make this clear. If there's a temporary injunction here and he violates a temporary injunction, he can go to jail. If he violates the Rule 11, he doesn't go to jail. So I don't know if Mr. Wade doesn't care about going to jail, if he's not been to Loose Sterrett lately, not a nice place to be. But I disagree with you strongly that there's no difference between a temporary, but when I make an order, it's enforceable. And I'm not trying to be like high and mighty, but when a court makes an order, it's enforceable by contempt and you can put him in jail. If the parties reach a Rule 11, you'd have to sue over it. So I don't think that's the same. But you would have to take the initiative. If he violates the temporary injunction, then hold him to the mat and let's put him in jail. That's my feeling, if he doesn't. But it's not the same as a Rule 11.
Your Honor, I agree with what you're saying. I'm just merely stating that in the interim, he apparently shows no concern whatsoever for the Rule 11, which was filed. But if the parties will agree to an agreed injunction, we will certainly go along with that.
And I'll order you to, and Mr. Janender, I'll order you to mediation at the time you suggested, if you'll agree to the injunction.
Thank you.
If you'll agree to the injunction.
Mr. Mills,
The terms,
Mr. Mills will not oppose entry of the injunction, Your Honor.
With the
We're talking
terms of the
about
Rule 11.
okay,
Yes, sir.
then yes, we will agree to that as well.
Is that Mr. Wade's attorney? I can't
Yes,
see on the.
this is Ms. Figueroa.
Okay.
Yes.
So I want to make it 100%. Tony, are we, I apologize. Are we on the record, Tony? I've had so many hearings I've watched. I don't remember if I'm on the record or not.
No, sir, you didn't say go on the record.
Okay. All right. So I want to make this clear. I want to get a yes, yes, yes. So if there's any, speak now, forever hold your peace. I'm going to announce the cause number and the case number. And then I'm going to ask if everyone will agree to a temporary injunction based on the Rule 11 entered. I don't remember which date the Rule 11's entered, but what date was the Rule 11 entered?
I think that 28th.
28th of what?
May
28th. Everyone agrees to enter the temporary injunction based on the Rule 11, on the terms of the Rule 11, that there will be a mediation ordered with Mr. DeGroot on what day?
Wednesday of this week, which is the 26th, Your Honor, at 4 o'clock.
And at 4 o'clock. And do we have a trial setting on this case?
No, Your Honor.
Okay. When do we want to, we have to set this for trial and agreed, we need to get a bond and a trial setting. So when do we want to set this for trial? Maybe next May, June?
As early as possible, Your Honor, but I think May would work for us. Your Honor, there is one other matter that is somewhat related to this, but we are concerned, and this is testimony that Mr. Holder, I think, could provide about threats that Mr. Wade has made to terminate certain employees in connection with the restrictions that have been placed on him. We'd like to, and I don't know why the defendants wouldn't agree with this, but we would like to have some prohibition against him terminating Mr. Holder, for example, and a woman named Marianne Franklin, who is basically the person who handles the revenue that actually provides for the business. And it just that he be restricted from terminating those two people.
Your Honor, this is I'm sorry for jumping in. It's Paul Janenda. This is where the pleading defect is a problem. His clients don't have the authority to seek that relief.
It's not part of the Rule 11 agreement.
That too.
No, it's not.
Your Honor, my concern is that the Rule 11 agreement provides that Mr. Holder is the one who's supposed to supervise what's going on here. And I am afraid that to the extent he is still there trying to supervise this, and Mr. Wade is able to direct employees in the company to send money to him and would give him an opportunity to violate the agreement, I would just like to make sure that there's some protection for those people under the
Your Honor, sorry, I didn't mean to interrupt, but this defect in the pleading was raised in June. And so it's unclear as to why, if this is such a big concern, why that defect in the pleading wasn't corrected when the second amended petition was filed, in which case the company would have counsel here to represent its rights and interests and would be able to, if this was a concern, would be able to speak to those concerns. But the relief that's being requested here is going to impede and impact the rights of the company. And the company is not a party and is not represented here today.
Your Honor, we are bringing suit as derivative plaintiffs on behalf of the company. And so for that purpose,
let me just say this. Pigs get fat, hogs get slaughtered. You're getting what you asked for. Now you're asking for more. You may blow up this whole deal. Are you sure you want to do this, Mr. Terry?
Your Honor, if that provision would blow up the deal, we certainly don't want to do it.
Okay.
I'm just thinking in terms of the practical effect of this.
I mean, I really think given the terms of this order, if he tried to do that, that would be extremely problematic, especially trying to direct other people to do things. I mean, the only time I've ever put anyone in jail is for violating an agreement almost exactly like this one. So he needs to know that this is serious, and with the temporary injunction in place, your client is a lot more protected. But if we fight this out and slog it out and look at the pleadings and do all that kind of stuff, you may get a lot less, you may get more, but I think you're really getting what you need with this. But I can't force you to make an agreement. I'm just telling you, I think you're making a mistake. So you want to do this agreement or no, Mr. Terry?
We'll do the agreement, Your Honor.
Mr. Janender?
Yes, Your Honor. And obviously, Judge, if we were to get this settled, I think it's already been noted that one of the effects of the settlement would be Mr. Wade wouldn't be in a position to do what Mr. Harry is concerned about occurring.
Okay, so what we're going to do now, everyone's in agreement. There's no more things we need to discuss before I go on the record, right?
Correct.
Yes, Your Honor.
The other attorney, I'm sorry.
Yes, that's correct.
Okay. Tony, ready to go on the record?
Yes, sir.
We're going on the record on cause number 206209, Baldetero v. Wade and Mills. Counsel, make your appearances.
Pete Harry with the law firm of Peter J. Harry, LLC, on behalf of the plaintiffs.
Nicole Figueroa with McDermott, Will, and Emery on behalf of Richard Wade.
Paul Janender and Amanda Prue, Wildgotchel, and Manges for defendant William Mills. Thank you, Judge.
All right, so we've had an extensive discussion off the record about this case. The parties have agreed to enter a temporary injunction in this case, based on exactly on the Rule 11 agreement from May 28th of 2000. They've also agreed to attend mediation with Mr. DeGroot on Wednesday, the 26th, and they've also agreed to a trial setting. In fact, I don't think we did figure that out. So how does so first off, is all of that agreed to? Plaintiffs?
Yes, Your Honor.
Mr. Janender?
Yes, Your Honor.
Ms. Figueroa?
Yes, Your Honor.
And how does May 25th sound for trial, 2021, or does that work for everyone?
Yes, Your Honor.
That's fine, Your Honor.
Yes, that's fine, Your Honor.
All right, we're going to set this for trial May 25th, 2021. All right. Anything else we need to chat about on the record?
Judge, the only thing I know you mentioned the open issue of a bond.
Oh, yes. How much of a bond would we need in this? Did you guys reach an agreement on that?
Your Honor, I don't know that we have, but we would ask for something completely nominal under the circumstances. We're just enforcing a Rule 11 agreement that the parties have already agreed to. So
Sounds fair to me. Mr. Janender?
I would defer to Ms. Figueroa on
Ms.
that.
Figueroa, what do you think?
That's fine, Your Honor.
How does 1,000 sound?
Yeah. No opposition, Judge.
Ms. Figueroa?
No objection, Your Honor.
no
And Mr.
objection, Your Honor.
All right, so $1,000 bond. All right, great. That sounds good. Go ahead and get me an order on this and with an agreed temporary injunction, and I will sign that. Try to get it to me if possible by tomorrow morning. I'll be in the office and I can sign it tomorrow.
Judge, one thing, Your Honor, Paul Janender, can you make, and I think verbally is fine, the order that you had referenced in terms of mediation this Wednesday?
Oh, yes, I did say that earlier, but mediation is ordered to take place on Wednesday, the 26th. All parties are required to attend it. And Rhonda, if you could go ahead and prepare an order. Can you spell, I don't know that, I think Mr. DeGroot's on our list, but just in case, can you go ahead and.
Sure. Judge, it's John, middle initial S as in Sam, DeGroot, capital D, little e, capital G, R, O-O-T-E.
Great, perfect. All right, anything else we need to chat about?
Your Honor, just for purposes of how this mediation is going to work, I've got one principal client and a number of derivative clients. Are you wanting to have every one of those people available by Zoom, or?
Whoever can, anybody who is necessary to make a decision in the case needs to be there on Zoom. So whoever the decision makers are.
Okay, Judge, thank you.
And I'm not sure who those people are exactly, but all right, does that address that?
Yes, Your Honor.
Okay. All right, anything else, guys?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Okay, I'm glad we got everything worked out, and that will be it for today. You guys are excused. Just make sure you get me an order by tomorrow, okay?
Thank you.
Yes, Your Honor.
Thanks, Judge. Have a good evening.
Yes. You too.
Bye-bye.
All right. So, Mr. Herrera, Mr. Builder, do you guys want to try to finish this hearing, or what do y'all want to do? Oh, and we'll be off the record now. Tony.
Yes, Your Honor, given the ruling on the motion to compel, I would argue that this motion for summary judgment is not ripe. And we either need to have that denied or reset while this discovery gets produced.
I would argue the motion for summary judgment is ripe because none of the findings can possibly change the lack of any evidence in support of the plaintiff's causes of actions. For example, in the causes of action, which is stalking, the plaintiff alleges that I violated the temporary restraining order, yet they have not produced the temporary restraining order simply because it does not exist. If there is no temporary restraining order I violated, the whole cause of action is invalid. It's moot. They're also alleging that I've made or employed someone else to make recordings or wiretappings of Mr. Zedrick and members of his family. They produce no evidence in support of that. In fact, in their response, they produce a piece of my affidavit that, sorry, not my affidavit, but a piece of my depositions which proves the opposite.
Your Honor, we disagree with all of that. I would just add that a prerequisite for no evidence, as you know, no evidence summary judgment is that an adequate time for discovery has passed. And we clearly have not had that in this case because the defendant has not complied with the request for production.
But wait. So, but what discovery that I ordered today that would be necessary to respond to this summary judgment? That's really
Well, Your Honor, I mean, I'm just thinking of a couple of examples. I mean, communications regarding my client, evidence harassment, or you know, posting online, which the defendant has a propensity to do about my client, evidence harassment. The actual recordings of the Skype or telephone calls that are the subject of a wiretapping claim. I think there's several requests that go directly to these claims.
If I may.
You may.
Mr. Rema, almost a year ago, instead of hundreds of questions that your client has been serving me with through you, including questions like if you lied once in your life, if you lied 5 times in your life, or admit or deny that grizzly bears are dangerous, and I'm not joking.
Those have all been withdrawn,
Mr.
Your Honor.
Rema,
They're irrelevant.
they were sent by you, and the rest is the same. Almost a year ago, when the majority of the case has been dismissed under the TCPA, you have said, me and Mr. Campbell have sent you 7 questions, all relevant to your causes of actions. Question number 1 for the cause of action, stalking. You allege that I have violated a temporary restraining order. Please produce a temporary restraining order. There is no temporary restraining order. Here are all the folders that you have produced. In those folders, we have my old depositions and even carefully tucked pages of articles, what to do if you've been followed by a narcissist. But no temporary restraining order because it does not exist. Period, end of story. When you're talking about alleged violations and wiretapping, and there is my deposition where people are asking me clearly, have you instructed anyone to make those recordings? And I'm answering, no, I have not instructed anyone to make those recordings.
Okay, response.
Well, Your Honor, there's 3 different restraining orders that we have articulated in our response to his summary judgment. One in this very court that is still being violated to this day. Secondly, in regards to wiretapping, even if what he says is true, he's still liable because if he uses or divulges information that was intercepted, there's liability built into the statute. Now, our burden here is low, as you know, it's just until of evidence, and we certainly have met that burden. In addition, we think there's still outstanding evidence that will bolster our claims.
Okay.
If I
Go
may.
ahead.
Mr. Rema, you know very well there are no 3 temporary restraining orders you're talking about. There is 1 restraining order, which is in this court. There has never been temporary restraining orders in the family law courts. Your clients have been left out of the court because they were trying to get a TRO for honking next to their house. Your client, Mr. Zidrick, filed frivolous lawsuit against me in 2017 in the heat of the child custody battle, and they were pushing it through the courts back and forth for 4 years. They have finally lost a month ago. The moment your client was forced to produce some evidence in support of their 2 remaining claims, they non-suited and the judge dismissed the case. 4 years, Mr. Rema, and Your Honor.
Your Honor, I'm not the attorney of record in this case.
Hundreds of billable hours, all with nothing. And you're here to stay in this court. Now we're going to produce this. Now you're going to produce that. Show me the temporary restraining order or admit there isn't one. You had almost a year to produce that. Here is a folder that you have sent me. It doesn't have a temporary restraining order that I allegedly violated. You have filed 2 motions for contempt in this very case against me, but you never set it on hearing. Why? Because there were no violations. Because we're in the middle of the child custody battle in Collin County case, and Ms. Sitnyanska, who is Mr. Zidrick's wife, has threatened me that I will file a lawsuit against you, or my husband will, if you don't give up custody on your child. And that's exactly what happened. And Mr. Zidrick has filed this lawsuit. So,
Your Honor, I'm trying to narrow the focus here. I'm not the attorney of record in the family case, so I can't speak to some of those allegations, but I think our evidence shows that there are multiple restraining orders that have been entered in that case. I have supporting evidence from my client, a declaration in support of that. I also have a letter from his former attorney in that matter that supports the idea that there are restraining orders. And as you know, there is an injunction in this matter that prohibits the defendant from approaching my client or from posting online about him. It's been violated multiple times.
But why would we deal with that? We do that through a contempt order, right? Not through this.
Right. I have filed a motion for contempt, and I'm waiting for a show cause order to be signed. But
you took down the hearing on the motion to contempt in spring. Come on. And you say that there are 3 temporary restraining orders circulating. Here is a request for production that you provided. Please show me where in this folder are those 3 restraining orders that I violated. Because in April, you signed a Rule 11 agreement when I was going to compel your production that this is all you have. There are no restraining orders. Can you please confirm or deny that there are no restraining orders from the court signed by the judge in the materials that you have produced? Maybe I missed something. Maybe I overlooked. There are 7 folders. Are there any TROs signed by the judge, Mr. Rema?
I know there's a temporary restraining order entered in the Denton County Court. I'm not sure. I believe that was produced, but I can't confirm that without looking through it.
There's
a temporary restraining order in Denton County. There was also an oral restraining order telling the defendants and the plaintiff to stop filming each other. That was violated. And as I said, there's an injunction in this matter.
Mr. Rema, here is a file you produced. Where is it? Is it in this file?
I don't have access to the file right now.
Can you say yes or no? Have you produced the temporary restraining order you allege that I violated? Because in Denton County, there were no temporary restraining orders, period. And there is no such thing as a verbal restraining order. You know it better than I do. I'm not a lawyer, you are. Your Honor, I'm sorry. This is preposterous. People are saying that there are 3 TROs against me. They cannot produce even 1 because they do not exist.
I think we're getting a little far afield of what we're talking about right now, which is, I will say that I am a bit frustrated in this case that we keep setting things for show cause orders and things like that, and they keep getting, it seems like they keep getting canceled. So I guess I'm still a little unclear. You know what, I'm going to allow a continuance on the motion for summary judgment to allow discovery to take place. Do we want to do the attorney's fees today?
If possible, yes.
Your Honor, I would just add that it's been discussed before, and I believe you said previously you're going to reserve that ruling for final trial. So I would.
Did I say maybe that sounds like something I would say.
Mr. Cook was at that hearing. I was not there, but that is what he told me. So.
All right.
If I may, Your Honor.
Yes.
Your Honor, you can see this case for what it is. Mr. Zidrick has lost his frivolous case in Collin County a month ago. Now we're here, and TROs that are not here, and we're continuing this case. There are contempt motions which are set and then canceled the very same day that the hearing was supposed to be. I'm pretty tired of that pushing. I had to have Mr. Campbell go. I have to push this case on my own. In the meantime, Mr. Zidrick has filed 2 or 3 additional lawsuits against me in Collin County alone and sent dozens, and I'm not joking, dozens of subpoenas all over the place, subpoenaing my semi-grandparents here in the United States, friends, businesses, which have some, even the most distant relation to me. And I still owe Mr. Campbell a substantial amount of money. I believe that the motion for summary judgment will be heard soon after I respond to the production, but Mr. Campbell has to be paid.
I do think, to be honest, that I kind of have to rule on this now because there's deadlines within the rules. What is the deadline on how much time I have to rule on the attorney's fees? Let's see. Let's see, I don't have my, does anyone have their TCPA?
I'm trying to find mine, Your Honor. 1 second.
What is the deadline to rule on TCPA motions? I thought I had mine. If you guys can't find it, I know where mine is. Give me a second. I'll be right back. This is a good thing for the interns to research. If you can find out how much time there is.
Your Honor, I believe it's 90 days after the service of the motion. It's 2704.
That I have to make a ruling.
Correct.
All right. So I think I have to make a ruling on the. Is there any case law on when the attorney's fees have to be paid?
I'm unaware of that, Your Honor.
Okay. All right. So let's go ahead and deal with the attorney's fees issue. I think he submitted 19,000 or something for the attorney's fees. What's your response?
I would say it's wholly deficient. And his affidavit does not comply with LAPL, which is the current attorney's fee standard articulated by the Supreme Court. There's no proof of the nature of the work, who performed the services, when the services were performed, the number of hours. I mean, he says a lodestar, I believe, with the number of hours and his billable rate, but the Supreme Court has said that that's not good enough. There's no billing records to validate his time spent or his billable rate or what was spent. So I would say that on that record, this attorney's fees cannot be awarded.
Oh, if I may, Your Honor.
Yes.
The plaintiff has requested those very things in his first request for production, so we can go back to the motion for attorney's fees when I produce the billing statements from Mr. Campbell, which would satisfy the plaintiff's attorney.
But I think that's very fair. What is my 90 days? When does it run?
I believe it's already run, Your Honor. The TCPA motion was heard last September, I believe.
Mr. Herrera, I mean, I have to award attorney's fees here, right?
I believe so. I was under the impression this would be done at final trial, and I thought we'd reached an agreement. I'm taking over from Mr. Cook here, so there's some things I'm unaware of what was said at certain hearings, but my understanding was this was reserved for final trial, and that was allowable. And we understand that.
I'll go with Mr. Stanislav's suggestion. I'm already past the 90 days, so either of you guys can mandamus me, I guess, if you want to get this decision made. But if Mr. Stanislav is okay with delaying this, then I'm okay with it too. Are you okay with delaying this?
I am, Your Honor.
I was asking Mr. Stanislav.
Oh, I'm sorry.
Yes, I will provide the billing statements from Mr. Campbell, and we'll get back to the issue pretty soon.
So you're not opposed to moving this hearing?
I'm not opposed to moving this hearing.
Okay. When do you guys want to reset this, or do you just, why don't you do this? Get the discovery exchanged, and then reset the summary judgment and the attorney's fees at the earliest possible date.
Very good.
Okay. All right,
Apologies
guys.
for the delay, Your Honor. I appreciate your time.
Sound good?
Yeah, this was
Thank
a long
you.
one. I'm about to scan in the order compelling the order on the compel right now. So you
Okay.
guys have a good day.
Thank you.
Thank
Have
you.
a good evening.
Have a good evening.
Bye-bye. Tony, we're finally done. This was a long day. Rhonda, I'll be in the court tomorrow at 9 or a little before 9. I think Miss Munder, you're going to be in as well. You guys can unmute. Go ahead and unmute.
Yes,
So who's actually coming in tomorrow?
I can stay until about 12:30. That's all. It's okay.
And then perfect. Andrea, you only do Mondays and Wednesdays, right?
Yeah, I have class from like 9 all the way till 4:30. So I could pop in for maybe an hour, but that's about it.
You don't need. I don't know really how long tomorrow's going to last. The trials these days are so unpredictable of what actually goes. So we do have a few. Only non-juries can go, and there's only a few of those on the docket for tomorrow. So we might be done in 10 minutes. It might be 2 days. We just don't know. And then Miss Lee, you come back what day again?
On Friday.
On Friday. Okay, we'll see you on Friday. We'll see you, Miss Lee. I sent you the link for that that one meeting, and the other meeting, if it happens with the judges, I'll send you guys all the link for that. Will be at 4:30, but we don't. It's not set as far as I know.
Will you
Oh,
be in the
oops.
courtroom on Friday?